Hello and welcome to this episode on fundraising and the provisions relating to it in the Companies Act 2013. To discuss these provisions, we have with us today Mr. K. Sethuraman, Group Company Secretary, Reliance Industries Limited, and Sharad Abhyankar, Partner Ketan and Company, a national law firm. In this episode, we're going to talk about what is a public issue, what is a private placement, the issuance of securities to raise money, the acceptance of public deposits to raise money, and the registration of charges in connection with fundraising. So may I begin by asking you, how is it that the Act deals with issuance of securities?
The Chapter 3, which deals with the matter of issue of securities, has divided into two parts, one dealing with the public issue, another dealing with the private placement. A public issue is the one which is offered to the public, which is not considered as a private placement. And a private placement has been defined in the Companies Act 2013, especially under Section 42 of the Act, saying that a company can offer securities in a financial year to not more than 50 persons, but as such a higher number as may be prescribed by the government. The draft rules say now the company can offer by a private placement in a financial year to persons not more than 200.
Right. So long as you offer it to 200 people or less, if these rules become law, you will not be considered to have made a public offer.
That's right.
Right.
Then coming back to the public issue, there's a separate chapter dealing with a matter whereby company have to issue a prospectus. The public issue includes even offer for sale also. Offer for sale can be, an unlisted company can make an offer for sale by the major shareholders. That will be a public issue. Even listed company, in a listed company also, major shareholders would like to make a further offer of securities, they can go through the process of public issue as well, which has been now defined well in the Act.
So Sharad, do you want to come in and talk a bit about prospectus and what happens in a prospectus? What does the Act say about what a prospectus should do? And when what you said in the prospectus turns out to be inaccurate. We've talked in another episode about criminal liability, which you were a part of.
Right.
So if you could focus on the civil implications of misstatement in a prospectus as well, while you deal with the prospectus.
When you are really issuing any securities, whether it be shares, that is equity shares, preference shares, or even shares with differential voting rights, a company while making any public offer is required to make an offer document. Now, the definition of prospectus is wide enough to include any notice, any advertisement, any pamphlet, anything whereby a company invites members of the public to subscribe is construed to be a prospectus. And once it is construed as a prospectus, then obviously, unlike 1956 Act, there is no schedule of contents really included in the 2013 Act, but the chapter, part 1 of chapter 3 itself identifies several things that must be included in the prospectus.
Right.
So rather than a schedule, the section itself deals with what should be contained in the prospectus.
Right.
And as compared to the previous law, now there is one major change, that is the definition of promoter.
Mm-hmm.
The SEBI ICDR regulations already define a promoter in a particular way. The Companies Act 2013 goes a little way beyond that definition, so the promoter concept is much wider as compared to the existing ICDR regulations, which is also to make sure that any misstatement, any wrong, erroneous impression that may be created, that may induce third parties to invest in shares, persons can be identified who can be penalized for such a misstatement.
So wider range of people would
So
become
wider
liable.
range of people will be identified as promoter, which is a good thing, because it's much more subjective. So to one extent it is a challenge, but at the same time it includes much wider range of persons who should be and who can be identified as promoters. Apart from that, there are a list of things that must be included, and some of the new things are that if the projects are going to take a longer gestation period, then what is that gestation period now needs to be clearly identified. And when it comes to the objects of the issue, apart from object of the issue, I think over the years it's just a learning curve that when objects are relating to a particular project, it is seldom identified as to actually it's going to take 5 years, 6 years, 7 years kind of period to actually deploy all the funds that you raise out of the public issue. So there are also certain things which now the Act identifies which are not required to be included in the prospectus, and so some of them are the expenses of the issue, which used to be a very stereotype inclusion in the previous law, is no more required to be stated. Principal terms of loans and assets charged as security, these again are not really to be identified in the prospectus, because these are principal contracts which are on an ongoing basis and in normal course. Details of material contracts, again it doesn't need to go into as much details as we used to do in the past. Is that if there are any auditor qualifications pertaining to the accounts for in last 5 years, they need to be highlighted. If there are related party transactions in last 5 years, those also need to be highlighted in the prospectus. So these are some of the new things which have emerged from the 2013 Act.
Can we talk a little bit about what the Act does in terms of companies which say they are raising money for a specific purpose, but then later say that commercial exigencies have changed and they need to deploy the same money now for a different purpose? There's been a lot of this issue about vanishing companies in the old law. So what does this Act do to that area of activity?
Yeah, the corresponding section in this one is 27 of the 2013 Act. It talks about a situation of the nature happens. The company has to secure the shareholders' approval by passing a special resolution as against ordinary resolution under the 56 Act. Besides that, the company has to give a wide publicity of the various variations what is being proposed to be done in the newspapers, and shareholders' approval should be taken by conducting a postal ballot as per the draft rules.
Should it be a special resolution or a
special resolution, and the consent will be taken by the shareholders through a postal ballot route, not by convening a meeting as such. Again, those who are not consenting to this particular variation, they should be given an exiting opportunity, and they will be given the price of the shares as per SEBI formula by the promoters and controlling shareholders. That is another important aspect one has to notice.
Right, which may also trigger an open offer obligation, the takeover regulation. It could.
It could, but I think the proposition that although it looks very onerous on promoters, because having passed a special resolution, having got the consent of substantial part of shareholders, to compel promoters or controlling shareholders to acquire the stake of all dissenting shareholders,
right,
and definitely at a SEBI determined price, will be a deterrent
right,
to a recurrent change of objects,
right. So
because in a way it is bringing some discipline to.
Right. So it's more a disincentive than a license condition.
Absolutely.
To change your contents. So can we talk a bit about what if the contents of the prospectus were misstated? What if the issuer or the person doing the offer for sale were to effect misstatements in the prospectus, not be truthful in it? We've discussed the implications of fraud, but otherwise what are the implications in the Act?
So section 35 deals with civil liability on misstatement, And what it does is it makes every director, any person who authorizes the issue of a prospectus, or a promoter, or even an expert who is named in the prospectus as an expert, the Companies Act now makes all these persons responsible on a civil liability, and the civil liability is a little higher than what we expected under the 56 Act. It makes them liable to pay compensation to every subscriber of securities. So it is not merely a civil liability standard of the 1956 Act. It now makes them liable for compensating every shareholder, every subscriber who would have come in the test is really that subscriber should have sustained a loss or damage. So there is a little bit of a check and balance. So it's not necessarily every subscriber who should take the benefit. Unless there is a loss sustained, the liability will not arise. However, if there is any intent to defraud, clearly the provisions of 447, 448 will trigger, and there is a much higher financial penalty, there is much higher imprisonment penalty that will kick in.
Right.
To supplement what Mr. Sharad mentioned over there, coming back to civil liability, those people whom he narrated, he mentioned or enumerated, will be personally liable and without any limitation of liability.
I see.
That is another aspect, which has been brought out in the 2013
So this would
Act.
be an interplay of the Indian law on damages under contract law and the special law vis-a-vis contract being the prospectus being misstated.
Right.
Can we now move on to the debentures side of the provisions? And could you give us an overview as to what are the provisions on debentures, what can be done, cannot be done?
Debentures, if they are issued as secured debentures, the company has to have the securities created. And it can be by way of mortgage or hypothecation of assets. And you have to have a value equivalent to the debentures what you are raising as resources over there. Apart from that, the company has to create a reserve to redeem the debentures to the extent not less than 50% of the value of debentures before the redemption starts. Apart from the creation of debenture reserve, the company has also to put in liquid assets every year on respect of debentures which is getting redeemed during the year and the year following by a specific percentage.
Redemption reserve.
Redemption reserve. Not only creating a reserve, but also deploying the funds by earmarking in liquid securities. Okay. That is another requirement which has been brought out in the Act. Further, a company which has issued debentures to more than 500 persons has to have necessarily a debenture trustee.
Okay.
Then coming back to redemption period, if no debentures issued by the company can be redeemed beyond 10 years.
Okay.
In the case of...
So, it's a maximum tenure of a debenture.
An exception has been carved out in respect of companies which are infrastructure companies, where if infrastructure company issues debentures, it can redeem debentures beyond 10 years up to a period of 30 years time as such. An exception has been given. That is another thing. Akin to if a infrastructure company issues preference shares, they need not have to redeem within 20 years time, they can redeem beyond 20 years time. Otherwise, a section dealing with the preference shares issue talks about a redemption period of maximum 20 years time.
Right.
Beyond 20 years, infrastructure company can redeem the debentures, like here also by the rules, up to 30 years time.
So debenture cap 10 years, preference share cap 20 years.
Yes.
So is there any insight as to why this cap on debentures is necessitated?
Yes, debenture is actually in the terms of liquidation, you're supposed to get prior to the preference shareholders. So therefore, it is in the fitness of things has been felt that 10 years would be the maximum period by which it can be done. Second aspect, I would view a preference capital has been considered, although a debt in the IFRS requirement regime, it has been considered even for determining a company as a holding company, subsidiary company. As we normally know that a subsidiary company is created out of control on equity shares, this 2013 Act has brought out a new what do you call an ambit, new definition, a definition whereby total capital of the company should be aggregated, on which if anybody holds more than 50% of that capital, that would be a holding company. Here total capital includes preference capital. Therefore, preference capital should get a lesser priority in redemption than the debentures.
I see. Can you very briefly touch upon the voting rights on preference shares? In what circumstances and what manner in which it would arise and fall away?
Yeah, presently, the voting rights actually is conferred on the preference shareholders in the event of not getting
under the 56 Act.
56 Act by dividend not being paid, and they are divided into 2 years in the case of non-cumulative cumulative preference shares and 3 years for non-cumulative preference shares. The new Act has brought out uniformly, if a company fails to declare dividend for 2 consecutive years, both on cumulative and non-cumulative preference shares, they will get the voting rights and they will have the right to vote in the shareholders meeting.
So in proportion to the face value.
Face
the
value.
Face value of preference is to
paid up value, I would say.
Right, paid up value. Paid up value of preference capital is to paid up capital of equity capital. Will be the ratio in which the voting pool of 100% will be divided.
That's right.
Okay. Should we move on to the issue of deposits and the issue of acceptance of deposits? And may I request you to first explain what is a deposit and then go into both of you in terms of what is the law on acceptance of deposits from the public, what are the issues to be borne in mind, and what is the compliance requirement in that regard?
A deposit is any money received by a company in the character of a loan is a deposit. So really any borrowing technically will fall into the omnibus basket of a deposit.
Right.
Having said that, the current regime, the 1956 Act, very clearly identified that a private company could actually raise deposits from its members, directors or their relatives.
Right.
Whereas in the current, the 2013 Act makes a clear departure and says a private company cannot accept deposits. A public company in normal course can accept deposits from its shareholders. So again, there is no bar to for a public company generically to raise deposits from its shareholders. But when you want to go public, there are two criteria that you'll have to satisfy. One is you need a clear shareholders' consent by means of a special resolution that the company can raise borrowed funds by means of deposits, and there is a formal process whereby you will, like an offering document, there is a circular with identified disclosures. Here again the rules when they come in will identify the types of companies which can actually raise deposits from public. So apart from, not that every public company will be by itself entitled to raise deposits from public just seeking the shareholders' approval, but it will have to be a category of a company which is permitted by the rules to raise.
And that categorization would be in terms of scale and size of the company, or
which may rules are yet to be prescribed by the government for the particular purpose. While rules have been framed for most of the chapters, they are yet to declare the draft rules because they are in consultation with probably Reserve Bank of India and then give the results.
So what happens if that public advertisement or that public statement about deposit contains a misstatement akin to a misstatement in a prospectus? Does the Act get into it, or is it silent, or what's
There are two types of penal provisions. I would just say that if the company having accepted deposit either from the shareholders or from the public is not able to redeem the deposits on due date time, the company is responsible for a civil penalty of Rs 10 crores.
Okay.
Apart from that, the officers who are in default are also liable for a fiscal penalty of 2 crores besides 7 years imprisonment.
So the civil penalty will be under the adjudication procedure under Chapter 29.
Right.
And one of the novel
And if the
features,
misstatement in the act, that would be akin to making a false statement, or could then the provisions of fraud, etc. will have to be applied.
447
So the
will be
intention
applied.
to deceive, etc. would need to be
Very true.
dealt with. Okay.
Sure. And deposits for the first time in company law have been now categorized, and it's really for a company to decide whether they want to offer a secured deposit or an unsecured deposit. What we traditionally always believed, that a deposit is an unsecured debt. 2013 Act makes a clear departure to say that yes, you can offer even a secured deposit. There are certain obligations that, based on the rules as may be prescribed, there will be deposit insurance that may have to be taken by the companies. Similar to, again, as Mr. Sethuraman said about debenture redemption reserve, there is a liquidity reserve that needs to be kept aside by any company which is raising deposits to the extent of 15% of the redemptions during the year and immediately the year following the fiscal year. So for 2 years, repayments of deposits which are from the public, the company needs to maintain a liquid asset readily available for redemption, and it cannot be used for any other purpose.
Right.
Another noteworthy feature in the 2013 Act regarding deposit is a new provision mentioned in the Act. If a company has already accepted deposits from the shareholders or from the public, within 3 months from the commencement of the Act, the company has to file a return with the Registrar of Companies, setting out what is the deposits payable by the company on the date when the section comes into force.
These are deposits already accepted by companies.
By the companies.
Before this new law came into effect.
Yes,
Right.
because the new law talks about the procedure by which a company can accept deposit either from the shareholders or from the public. As Mr. Sharad mentioned over here, they have to take secure shareholders' approval. The existing deposits are not accepted by getting shareholders' approval. Therefore, in the fitness of things, the Act provides that deposit outstanding as on the commencement of the Act has to be repaid, for which the first stage is that the company has to file a return with the registrar within 3 months from the commencement of the Act.
Right.
Then we come to the repayment schedule. The Act clearly makes it clear that within the company has to refund the money within 1 year from the commencement of the Act, or if the existing tenure is preceding 1 year, whichever is earlier, the deposit has to be repaid. In other words, all existing deposits accepted by the company would be redeemed not later than 1 year from the commencement of the Act.
So can we now move on to the area of charges? Like when you raise money, you secure it, you create a lien, you create encumbrances. What does the Act do in terms of charges? Can you summarize the highlights and then get into the detail?
The definition of charge means interest on lien on securities of the company, assets of the company. Even a company has a lien on a particular property, it has to be charged. In addition to the mortgage and hypothecation, as hitherto we know under the 1956 Act, that is one major change. Coming back to the procedural aspect, I would simply say that a mortgage has to be created within 30 days time from the creation of mortgage. If a company is not able to create a mortgage within 30 days time, they can create by paying additional fee within 300 days from the date of creation of the mortgage over there. In the case of satisfaction, again they have to if they satisfy the a charge within 30 days time from the date of the satisfaction, they have to create a satisfaction charge. If they fail to do that one, within 300 days from the date of satisfaction, they can very well satisfy the charge over there. Beyond that period, if at all the company fails to do or for some reason it could not do that one, with the central government approval, it can be remedied, it can be further charge can be created, or it can be satisfied. If a company fails to create a charge within the time limit, as I mentioned to you, even the lender on his own volition can file the charge with the registrar of companies, whereupon the registrar will send a notice to the company before receiving the charge. In addition to that one, the charge register is open for inspection of the members of the company. Hitherto, under the 1956 Act, only the charge register can be open for inspection. This 2013 Act has brought out clearly that a member is entitled to inspect not only the register of charges, he can as well inspect the instrument creating the charge as well. These are the various changes in this one. Otherwise, there are not much changes in the provisions on the 2013 Act compared to the 1956 Act.
Right. Shiraj, you have something to add to the provisions relating to charges and registration?
So, one aspect that Mr. Sethuraman mentioned about the changed definition of charge. There are transactions where lien, that is pure custody of title documents, is offered as a security for repayment of the loans. Prior, under the 1956 Act, the definition of charge was did not include lien.
Right.
And to that extent, under the new law, even a custody of title documents which creates a security for repayment of loans, that will have to be registered as a charge by following the due process.
Right. Failing which it would be perfect security,
yeah,
and
that's right.
therefore a court need not enforce it.
Yes, it will remain void as against the lender.
Right.
Another aspect which has been brought out in this charge matter is through the draft rules, which is quite common for persons who are availing loan for buying vehicles. If the lender feels or he consents that hypothesis cannot be created on the vehicles purchased by the company, there is no need to create a charge.
Right.
And if at all that lender agrees with this effect, the annual report of the company should give a clear disclosure saying that the charge has not been created on the loans availed in their balance sheet. That is another requirement.
So would you say that with improved IT access and others, with this new law, there would be far greater transparency about our companies, particularly the public limited companies, and which of their assets are encumbered and which are not?
Absolutely. It will be made very clear about that, and then the shareholders' rights also is well taken into account in this new provision.
Right.
Yes, in fact, one of the ways in which the compliance is encouraged is to say that the register of charges maintained on the MCA website will be deemed to be the authentic record of charges.
Right.
So there is a special provision which really creates that as a binding record for all companies and all for stakeholders.
Right.
So that definitely will encourage the compliance both from the lenders as well as from the companies.
So from lending and borrowing and paying interest on it, if you could move back to securities and shares for a moment in the aspect of the returns on those investments, could you give us an overview of what is the law on dividend? When is dividend payable? What becomes a dividendable profit, if you could use that phrase, and any changes in these areas in the new Act?
Not much of a change in respect of dividend, except some procedures have been prescribed. As per the present Act, 1956 Act, dividend can be declared, as you know very well, only against company's profit.
Right.
Company has to provide depreciation and also set off all the past losses, if any. Thereafter, if reserves are available, free reserves are available, then only dividend can be declared. And under the 1956 Act, there is a requirement that if a company declares dividend beyond 10% on equity share capital, they have to transfer necessarily to the reserve account of a particular prescribed percentage, varying between 2.5% to 10%. Such a requirement is not provided in the 2013 Act. It is totally left to the company whether to transfer to the reserve account or not. This is one major change
General
between
reserve.
to general reserve
Right.
to this account. This is one change in the 2013 Act. Second one, if a company is to declare dividend the current year, there is no profit available or inadequacy of profit, it can declare dividend by withdrawing from the past year's reserves. In that event, they have to comply with certain requirements which has been set out in the draft rules. They are by and large same with the existing rules what is in vogue at the moment. As you know very well, the definition dividend includes interim dividend. A separate provision has been brought in 2013 Act. If a company intends to declare interim dividend, the board may as well declare interim dividend. Again, they can declare dividend out of past year's profit out of current year's profit. On the contrary, if the company in the current year has got incurred losses, in the preceding two quarters before the declaration of dividend proposed by the board of directors, the company has incurred losses, then the dividend cap has been prescribed. Board of directors cannot declare dividend, interim dividend. It may be even out of past year's profit or reserves over past year's profit. Then the dividend cap is not more than the last 3 years dividend rate, only can be the maximum under which it can be done. Another change in the new act is that after the expiration of 90 days from the date by which the dividend has been encashed by the people, in other words, after 127 days from the date of declaration of dividend, all the companies are now obligated to display on the company's website the name, address of the shareholders whose dividend remains unencashed. Presently, this requirement is applicable only for listed companies.
Right.
Now they are made applicable for all companies together. Another change over there is that, as per the present Act 56 Act, dividend if remains unpaid for a period of 7 years, the dividend will go to IEPF account.
Investor Education
Protection Fund will go.
Right.
The same 2013 Act also brings the same concept. In addition, by subsection 6 of 124, one more provision has been made whereby the shares of those shareholders also will be transferred to Investor Education Protection Fund.
So they'll get vested in the fund.
They will be vested in the fund.
Right.
A mechanism has been prescribed in the draft rules for transferring those shares from the shareholders, whether electronically they are holding it or physically holding, to the IEPF account.
Right.
Similarly, a mechanism has been prescribed whenever the shareholders come and make a request for getting the shares back. It has been provided clearly in the draft rules. Next, another important thing we have to notice in the new act is that once the money is transferred to IEPF account, it is not claimable. That is what 56 Act says. The 2013 Act clearly says money transferred to IEPF account can be claimed by the investors.
Right. Which is a better
thing for provision for this one,
right,
for which they are given a mechanism also what to do.
Okay. So, may I, before we wind up, invite you to summarize your own perspectives about this very important area of the Act, i.e. fundraising. Has it made life easier? Has it made life simpler? Has it made life more complex? If you could just give us a very broad overview on these 4 chapters that we discussed today.
My view is very simple. I think investors have to be clearly given a full disclosure of the company's objectives, company's status, and various things over there. Based on that, they take an informed decision in either subscribing to the shares or debentures or put the money in fixed deposits, whether as secured or unsecured. Should be well protected. If companies misstate some information in their documents for all this money mobilization media, and they are found something untrue or otherwise, penal provisions have been made very, very stringent. It is again a direction towards the investor's interest.
Sharat, would you?
One of the changes which is very interesting and noteworthy is lots of exemptions which were hitherto applicable as private companies have clearly been taken away. One of the essential protections that a private company as a structure had was to offer shares to not only its own shareholders but also to select group of people who are not holding shares. So the principles of a traditional rights issue are now becoming mandatorily applicable all across the spectrum of companies. So even private companies, as the rule of thumb, will have to first offer the shares to its own shareholders. Otherwise, we'll have to do a private placement.
Right.
Now, the interesting thing is, while a private company is able to raise its number of members up to 200, the definition of private placement has continued at 50. So, if a private company also wants to raise money by offering shares and wants to offer it to more than 50 people, other than a certain set of QIBs and shares offered under ESOP, they will have to perforce make an offer document.
Right.
So the prospectus,
under, of course, the rules which Mr. Sethuraman referred to, raise the bar to 200.
raise the bar. But that's in a financial year.
Right.
So even if in a single issue, if the offer was to be made to more than 50, currently as the Act stands, it will lead to a public issue by default, and therefore all the obligations of a prospectus and misstatement and disclosures will kick in, which is a welcome position, because particularly in closely held companies, not too many disclosures are really done and never expected. But with the additional burden, I think we will become more compliant, will become more transparent.
Right.
To supplement what Mr. Sharad mentioned, one more aspect also should be looked into. In the process of mobilizing resources, company also might come out with further issue of capital. It could be a right issue. It could be an issue at not to the entire shareholders community as well. In that event, in the case of a listed company, if the shares are offered by a private placement or not all the shareholders, the pricing will be as per SEBI formula, as you all know about it. Even unlisted public companies and private companies, if they make further issue of capital, not to all the shareholders by way of rights, they make it only selective set of people to a private placement, the share has to be valued by registered valuer. It can't be offered at par. Presently, there are no regulations talking about the pricing of the issue.
Right.
Now, it has been made clear that the valuation of those shares will be made by registered valuer. Only at that price it has to be offered.
But I think it will be difficult to get into every aspect of every implication. For purposes of this episode, we tried to cover a very high level but as intense as possible overview of these chapters. And I think that's all we have time for at this stage. Viewers are encouraged to actually read the provisions. We've covered chapter 3, 4, 5, 6 and 8. Do read the provisions yourselves. A 30-minute episode only gives us so much capacity to give you a broad overview. We hope you enjoyed this and you're able to use this as a basis to whet your appetite to actually read the relevant provisions of the Act. Thank you very much for taking time out for this session. Thank you.